John Marshall, early life. He was born on September 24, 1755 in Fauquier County. He was the oldest of 15 children, and his parents were Thomas Marshall and Mary Randolph Keith. He was mainly homeschooled by his father as a child, but he spent 1 year at Campbell Academy in Westmoreland County. John Marshall, Revolutionary War. General George Washington had a major influence on John Marshall. Washington inspired him to join the military at 20 years old. He wanted to take part in forming the new nation. He was appointed as lieutenant of a state militia called the Culpeper Minutemen. After the militia's victory, Marshall became an officer with the Continental Army's 3rd Regiment of Virginia. At the Battle of Germantown, he was wounded in the hand while leading a charge. At Valley Forge, George Washington appointed Marshall as his chief legal officer. Marshall took leave on furlough when he was stationed at Oak Hill in 1780 because he wanted to visit his father, who was stationed in Yorktown. Marshall met his future wife in Yorktown, Mary Willis Ambler, daughter of the Virginia treasurer. He left the military in 1780 to study law. John Marshall, law practice. In 1780, Marshall studied law at Judge George Wythe's lectures at the College of William and Mary in Williamsburg, Virginia. He was also admitted to the Virginia bar and began his own legal practice that same year. Most of his success came from defending clients against British creditors who attempted to collect debts incurred during the British colonial rule. John Marshall, government roles. Marshall began his career in government by representing Fauquier County in the General Assembly for 1 term. He joined Virginia House of Delegates in 1782, representing Henrico County. In 1785, Marshall ran for city council, but he came in second, so he was made city recorder instead. Marshall was able to establish a reputation for being a humble and fair man who communicated clearly and based his decision on the common good. Marshall became a delegate to the state convention in 1788. This was formed to ratify the United States Constitution. He also participated in replacing the Articles of Confederation with the Constitution. Marshall was invited to join the U.S. Supreme Court in 1798. He turned down the position but still participated in a 1797 diplomatic mission, the XYZ affair. Marshall was elected to a seat in the U.S. House of Representatives in 1799. In 1800, he was appointed Secretary of State under President John Adams. From 1829 to 1830, Marshall was a delegate to the Virginia Constitutional Convention with his Campbell classmate James Monroe. John Marshall, death. John Marshall served on the Supreme Court until his death. He died on July 6, 1835 at age 79 in Philadelphia, Pennsylvania. He was buried at Shockoe Cemetery in Richmond, Virginia, next to his wife, Mary Willis Ambler.
Now let's talk about a famous Supreme Court case, Plessy versus Ferguson. What is the Plessy versus Ferguson case? The Plessy versus Ferguson case upheld the constitutionality of racial segregation laws for public facilities as long as they remained equal, a doctrine that came known to be as the separate but equal. Where and when did this case happen? This case happened in 1896 in Louisiana and was argued on April 18, 1896, which was later decided on that same year on May 18. Who were involved in this case? First, let's talk about the petitioner, Homer Plessy, who was 7/8 European, 1/8 African. He was a black passenger who worked as a shoemaker in New Orleans, Louisiana. Next, the judge or the respondent of the case, John Ferguson. He was the one who presided the case of Homer Plessy. But what really did happen? In 1890, the state of Louisiana passed the Separate Car Act, which required separate accommodations for black and whites on railroads, including separate railway cars. A concerned group of prominent black and white in New Orleans formed the Committee of Citizens dedicated to repeal the law or fight its effects. The Committee of Concerned Citizens persuaded Homer Plessy, a man of mixed race, to participate in an orchestrated test case. Plessy was born a free man and was 7/8 European descent and 1/8 African descent. However, under Louisiana law, he was classified as black and thus required to sit in the colored car. On June 7, 1892, Plessy bought a first-class ticket at the Press Street Depot and boarded a whites-only car bound for Covington. The railroad company, which had opposed the law on the grounds that it would require the purchase of more rail cars, had been previously informed of Plessy's racial lineage and the intent to challenge the law. Additionally, the committee hired a private detective with arrest powers to detain Plessy, to ensure that he would be charged for violating the Separate Car Act, as opposed to vagrancy or some other offense. After Plessy took a seat in the whites-only railway car, he was asked to vacate it and sit instead in the blacks-only car. Plessy refused and was arrested immediately by the detective. As planned, the train was stopped and Plessy was taken off the train at Press and Royal Streets. Plessy was remanded for trial in New Orleans Parish. So why did it go to the Supreme Court? Homer Plessy challenged his case in the Supreme Court on grounds that it conflicted with the 13th and 14th Amendments. The 13th Amendment, which states neither slavery nor involuntary servitude, except as a punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction. It is geared to abolish slavery, while the 14th Amendment aims to grant citizenship to all persons born or naturalized in the United States, including former slaves, and granted all citizens equal protection of the laws. So what was the decision? On May 18, 1896, in a 7-1 decision, the court rejected Plessy's arguments based on the 14th Amendment, seeing no way in which the Louisiana statute violated it. In addition, the decision rejected the view that Louisiana law implied any inferiority of blacks in violation of the 14th Amendment. Instead, it contended that the law separated the two races as a matter of public policy. But in the end, what do you think? Is it really separated but equal?